Welcome to the AskJunior Daily Judgment podcast. I'm Priya, and joining me today is Arjun.
Hello, everyone. We're excited to dive into today's important judgment. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our daily legal breakdowns.
That's right. Your support helps us reach more listeners and continue providing in-depth analysis of the latest court decisions. Now, let's get started with today's cases.
We're about to tackle a real legal behemoth today, Priya. The Supreme Court of India just released a massive judgment in the case of Aligarh Muslim University, AMU, versus Naresh Agarwal and others. It's a complex case with a long history, and this judgment could have major implications for minority rights and the role of the government in education in India.
You're right, Arjun. This is a case that has been in the courts for decades, and it finally came to a head with the Supreme Court's decision today. Let's break it down step by step.
Okay, so let's rewind the clock. The AMU, founded in 1920, has always had a complex relationship with the government. It was established by an act of the British Indian legislature, and it's always been under some level of government control. But the question is AMU a minority institution under Article 30 of the Indian Constitution? That article gives religious and linguistic minorities the right to establish and administer educational institutions of their choice.
And that's where the controversy lies. The Supreme Court, in a landmark case back in 1968, ruled that AMU was not a minority institution. The court reasoned that because AMU was established by an act of the legislature, the government, not the Muslim community, had the right to administer the university.
That's a big deal, Priya. It basically meant that AMU was subject to much more government oversight than other minority-run institutions.
And today's judgment is a big deal as well, Arjun. The Supreme Court essentially overruled the 1968 decision. It means the court has reinterpreted Article 30, and it could potentially have a major impact on how other minority institutions are treated in India.
But before we dive into that, let's talk about the case itself. The most recent issue that brought this case back to the Supreme Court involved a 2005 resolution by AMU's governing body to reserve 50% of seats in postgraduate medical courses for Muslim candidates.
And guess what, Arjun? The Allahabad High Court actually struck down that resolution in 2006, citing the 1968 ruling that AMU wasn't a minority institution. So it's kind of a double whammy. The court is now reinterpreting both the 2006 decision and the 1968 decision.
Exactly. And this new judgment is quite long, so let's first break down the issues that the Supreme Court was grappling with.
The Supreme Court looked at a few crucial things in this case, Arjun. First, they had to figure out what constitutes a proper reference to a larger bench. The case was originally referred to a 7-judge bench in 1981, and then again in 2019.
You see, Priya, the Supreme Court usually requires a bench of equal size to challenge a previous decision. But in 1981, a 2-judge bench referred the 1968 AMU judgment to a 7-judge bench. The court in today's judgment found that this was actually permissible because a smaller bench can question a previous decision without disagreeing with it. They basically said, hey, we have some questions about this, but we don't want to overturn it ourselves, so let's get a larger group to look at it.
It's kind of like a, we're not sure about this, but we think a bigger group should take a look scenario.
Exactly. And then in 2019, a 3-judge bench re-referred the case, arguing that the 1981 reference was not answered. Today, the court upheld that re-reference as well.
So, they're basically saying that since the question of AMU's minority status was never conclusively settled, they needed to get a larger group of judges to take a look.
Right. And then the court had to delve into the question of locus standi. That's a fancy legal term that means standing or the right to bring a lawsuit. They were basically trying to figure out if AMU could even legally argue their case in the first place.
And they decided that AMU does have standing, Arjun. They argued that, even though AMU was established before the Constitution was adopted in 1950, they could still invoke Article 30. They said that, while fundamental rights cannot be applied retrospectively to disrupt pre-constitutional practices, The appellant is not barred from asserting a claim under Article 30 as long as the necessary conditions of this provision are met.
That makes sense, Priya. It's kind of like saying that if a new law is passed, it can apply to existing situations, even if those situations started before the law was made.
Exactly. So, they're saying that just because AMU was established in 1920 doesn't mean they can't claim protection under Article 30, which was adopted in 1950, as long as they meet the criteria.
And this is where things get really interesting, Priya. The court then got into the heart of the matter. What does it actually mean to be a minority educational institution under Article 30?
And this is where they made a big change, Arjun. The previous decision, back in 1968, required an institution to be both established and administered by the minority community to qualify for special protections under Article 30. They called this a conjunctive reading of the article.
That's right. They were basically saying that the minority had to do both. They had to found the institution and also be in control of running it.
And that's where the court made its shift today, Arjun. They now say that you only have to prove the minority established the institution, not necessarily that they administer it. It's a big shift because it means that even institutions with a majority of non-minority administrators might still be considered minority institutions.
And to understand that shift, Priya, we need to understand what the court says about the meaning of establishment. The 1968 decision interpreted establish as meaning to bring into existence. But today's judgment is saying that establish means more than just bringing something into existence.
It's about intent, Arjun. The court is saying that the minority community must have had a clear intent to found the institution for their own benefit.
It's not just about who was involved in the paperwork, Priya. It's about the heart and soul of the institution.
You're right, Arjun. The court is now taking a more holistic approach. They're saying that we need to look at the genesis of the institution, how the idea was conceived, who played a role in its formation, and what its overall purpose was.
And that brings us to AMU. The court looked at the history of AMU's founding, and it concluded that even though it was established by an act of the legislature, it was founded by the Muslim community with the clear intent of creating a place for Muslims to receive education.
So while AMU was established by a government act, it wasn't just a government institution. It was a place that was rooted in the Muslim community's desire for education, and that intent makes all the difference.
Exactly. The court recognized that the Muslim community, led by Sir Syed Ahmed Khan, worked hard to raise funds, secure government approval, and ultimately bring AMU into existence. They recognized the Muslim community's role in the institution's founding.
That's a huge win for the Muslim community, Arjun. And it could be a big win for other minority communities in India as well.
Absolutely. It means that minority institutions have a much stronger case for claiming special protections, even if they are partially funded or regulated by the government.
But Arjun, it's not as simple as just saying, okay, now AMU is a minority institution, end of story. The court did emphasize that the government still has a role to play in ensuring that educational standards are upheld. They're not saying that minority institutions get a free pass from all regulations.
Right, Priya. The court said that government regulation is fine as long as it doesn't infringe the minority character of the institution.
So it's about finding that balance between protecting minority rights and ensuring that all institutions are meeting acceptable standards.
The court also acknowledged the fact that the AMU has, historically, been a secular institution, despite its name. They noted that it has never had a quota for Muslim students before and has always been open to people of all faiths.
That's an important point, Arjun. They're acknowledging that AMU's secular nature doesn't negate its minority status. The fact that it provides a space for Muslim students to pursue education is critical.
You're right, Priya. So, even though AMU may not be a strictly religious institution, it's still an institution that was founded by the Muslim community to serve their needs, and that gives it a special character.
This decision has a lot of implications, Arjun. It means that courts are going to have to take a more nuanced approach when considering the minority status of institutions.
Absolutely, Priya. It could mean that more institutions might be classified as minority institutions in the future. This new approach could lead to more diverse and inclusive educational landscapes in India.
It's a big win for minority rights, Arjun, and we'll be watching closely to see how this decision plays out in future cases.
We'll definitely be following this story, Priya. We'll be keeping you updated on all the new developments.
And that wraps up our analysis of today's judgments. We hope you found our discussion informative and engaging.
Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast. Your support means the world to us and helps us continue bringing you daily updates on the most important legal decisions.
Absolutely. And don't forget to tune in tomorrow for another exciting episode. Until then, this is Priya.
And Arjun, signing off. Thanks for listening to the Ask Junior Daily Judgment podcast.